A hidden crisis in South Africa's justice system is coming into sharp focus. Thousands of people are being held behind bars for years without ever being sentenced. According to the Judicial Inspectorate for Correctional Services and the Department of Justice, there are approximately 60,000 remand detainees nationwide, with around 5,000 waiting more than 2 years for trial, and a small but alarming number languishing for more than 10 years. The question now remains on whether the bail restrictions should be eased. To help understand this is Correctional Services Commissioner Makgothi Thobakgale, who joins us now. Mr. Thobakgale, thank you so much for the time. Appreciate it, Commissioner. Let's just talk about why we're sitting at this stage. What's delaying all of these sentencings?
Well, there are a number of reasons. If I may just give examples. The first one would be that there will be instances where the South African Police Service is still conducting further investigations. There will be instances where the remand detainees themselves, change their legal representation, meaning that instead of the case being, heard in court and progressing, you will have postponements, because once you change lawyers, the new lawyers, need to be briefed. In some instances, there will be a situation where there is no investigation officer allocated specifically for a particular case. So, as I've indicated, there are a number of instances.
So, would it be more helpful then, in that case, that if a case reaches a particular timeline, that maybe we should be re-looking at bail? Not necessarily that everybody gets bail just because it's taken some time to investigate, but that after a certain time that we re-look at those conditions just because of how long it's taken. If it's more than 2 years for about 5,000 of them at the very least, and 10 years for some, surely that's a very long time.
The law allows us, the Criminal Procedure Act and the Correctional Services Act allows us as correctional officers, in particular the head of centers, to submit to the judiciary applications for review of a decision not to grant bail, and also review of a bail decision. For instance, if a bail is set at 5,000 rands, we, in some instances, do apply that it be reduced to an affordable amount for the remandee to be able to get out on bail. There are those that do not afford bail at all. Even if bail is set at 100 rands, they just do not have that money or cannot raise that money. There are those that do not have family support, or there's nobody else outside who is willing to take the responsibility of being a guardian for this person. So without that, it is impossible for us to release, a person on bail, because obviously this person will go out. There's no guarantee that they will come back to court again, or they will not fall back to the life of crime. So as I was indicating, there are a number of variables, but the fact of the matter is we have them behind bars on a daily basis. They are costing the state a lot of money.
This means it's a conversation with the judiciary as well, right? Because it's a full understanding of the entire scope of what is needed here. Yes, you have what is applied to law, but also circumstances that need to be taken into account. Do you think that that might not be happening? And the fact that when bail is denied or maybe bail is given, that may not be taken into account, the ability for correctional services to deal with the backlog?
Well, these factors are taken into account precisely because we have structures. At a national level, we have what we call the National Efficiency Committee, where ourselves, Correctional Services, SAPS, the judiciary, meet twice a year. On a quarterly basis, our regional commissioners sit with the chief justices in the provinces, and also our heads of centers sits with the judges and magistrates to look at these cases, and we are able to process them. But what is important is that you can't process them as a number, like as you indicated, it's just over 5,000. You have to look at each and every case, her merit. So now that takes a bit of time, but in the meantime, we have to keep them in our custody. It contributes to prevention of crime also, but as one has indicated, it does cost the system quite a bit.
Yeah, it certainly sounds like it does. I mean, do these overcrowded facilities then hinder the ability to what's the right word, rehabilitate some of these prisoners as well in this case? Because it just means that it delays their rehabilitation, one, and it also just means that perhaps you can't actually look after them in the way that should be taken care of in that moment.
Well, in this case, we're talking about remand detainees. We're talking about those that are still going to courts or through the courts. The sentenced offenders do go through rehabilitation and correctional programs. What happens with the remandees is that we take them through behavior, modification programs. These are programs that are not that intense, but they're programs to raise awareness and to try and bring the person back from a life of crime to a life that, will be productive once they are sentenced or they are released. We normally target those that would have spent more than 6 months with us, obviously with the projection that they still have some time with us. But there are those that are habitual criminals. And that's where also the judiciary has a serious challenge to deal with. This is a person who would appear in court this week, given bail. After 2 weeks, the person has committed another crime again, appear before the same magistrate, been given bail, and, so we end up with them actually spending more time with us because as a magistrate, you can't keep on giving this person bail again and again. At some point, this person, you'll have to ensure that remains with us, so we are able at least to take them through some behavioral modification programs so that next time they don't go back to the life of crime. These are people who commit these crimes that are opportunistic, of economic nature, theft, stealing, and all that. But we don't want them to move beyond that level of crime to serious crimes. That's why we need to find a way of taming this behavior,
Commissioner,
as it were.
Commissioner, there's a proposal called the bail fund, which would in many ways be taxpayers helping to fund bail for minor offences. What are your thoughts on that? Should we be looking to administer something like that?
Well, the Judicial Inspectorate, which is an independent body that is meant to do oversight over our work as correctional services, is the one that is spearheading the bail fund. We support the bail fund because, as I've indicated, there are those that are behind bars that just can't afford. The judiciary would have, given them bail, but they just can't afford bail. So there you see a difference between someone who can pay his or her way out and a person who can't pay his or her way out. So a poor person doesn't have to be denied justice just because that person is poor. So that's where a fund like the bail fund will come in. Obviously, there will be conditions for a person to qualify to be supported through the bail fund. I don't think that it will be a fund that will just be accessible to anybody. I don't think that it will be a fund that is accessible to people who have committed some categories of crime. For instance, I would not support a bail fund to assist a person who has committed a crime that is associated with gender-based violence and femicide.
Yes.
So there will be those conditions, and it's a debate that is continuous. But yes, in principle, you shouldn't be denied of justice because you are poor.
Fully understandable. Commissioner, appreciate the time. Thank you so much. We're hoping to deal with the overcrowding in South Africa's prisons, particularly those who are remanded into custody.